So my name is Michael Pevney. I practice estate planning law. I am only an estate planning lawyer. That's the only type of law that I practice. So let's quickly jump into what is an estate plan. So an estate plan is a set of documents that you create, maybe with the help of a lawyer, maybe without, and it tells people what you want to happen with both your body and your stuff. First while you're alive, and then also after you pass away. So there are a couple of documents that are associated with a basic estate plan, and in my opinion, there are three essential documents to any estate plan, and in fact that everybody should have some sort of estate plan set up when you turn 18. Those three essential documents are, and this is for the absolute kind of basic level estate plan, and a lot of people, you can actually kind of do it yourself, is a power of attorney document. So that's a document that tells other people, financial institutions, who you want to be able to take over your finances if you are unable to. If you are in that hospital bed, you get to choose who's handling the finances, who's handling the bills. The second document is what we refer to in California as an Advance Healthcare Directive. And that document encompasses two things. It serves two jobs. First, it tells what your end-of-life decisions are going to be. And these are documents that are signed. They're either in front of witnesses or a notary or sometimes both. And it tells people what, ultimately medical professionals, what you want your end-of-life decisions to be. So please ask an estate planning question in the comments. You can follow my account for more estate planning information. And yeah, please ask a question, and that's what I'm here for. That's what I do. So we've got the financial power of attorney. We have the Advance Healthcare Directive that first tells other people what our end-of-life decisions are and also lets other people make other healthcare decisions for us. We get to choose what those healthcare decisions are. So the third sort of piece of the puzzle, leg of the stool to a basic estate plan, is a will. A last will and testament, and that's a document that says what you want to happen to your stuff, to your property. Where do you want it to go? And those three documents comprise the most basic estate plan, and sometimes those estate plans are actually available for free. Many states put out draft documents and possible estate plans out there for you to create on your own. I wouldn't suggest doing that. Typically, we want an estate plan set up by an attorney, but we're getting into August here. We're sending off kids to college. A college kid needs these sort of things. So I'm going to take this opportunity we've got a bunch of new people in here. I'm going to introduce myself one more time. My name is Michael Pevney. I'm an estate planning lawyer, so I create estate plans for families. I practice in the state of California. I'm only licensed in California, but some of the information you might learn here is going to be relevant to you. My ask is for you to ask an estate planning question in the comments, and I am going to get to them when I can. Please follow me for more estate planning information. I've got a bunch of videos here where I talk about estate planning. So what we first did is we went over the very basics of what any adult needs in place. A financial power of attorney, a healthcare power of attorney, also known as an Advance Healthcare Directive, and then a will. Now, we already have a couple of questions going on there about a trust. So what is a trust and how is that compared to a will? So please hit the like button there if you do not have some sort of a living trust set up. Furthermore, hit the like button and hit that heart or double tap that screen if you own real estate and want to make sure that it's passed on to the next generation in a responsible way. So at its very base level, a trust is a document that you create either yourself or with your spouse that tells people what you want to happen to your property, both while you're alive and after you pass away. And a trust is better than a will for 4 reasons. Those 4 reasons that a trust is better than a will are cost, control, privacy, and then time and hassle. When I talk about cost, I'm talking about the cost of probate. Probate is expensive, especially if you are in California. If you've ever been through or know somebody that's ever gone through the probate process, please let me know in the comments, and that'll be a little bit helpful. So please like this video if you're getting some information from it. Follow me for more estate planning information, and please ask an estate planning question in the comments. Much appreciated. So there are 3 essential people that are associated with the trust that have 3 separate jobs. There is the trustor, sometimes known as the trust maker. There is the trustee, and then there is the beneficiary. The trustor puts things into the trust. The trustee is in control of the trust, and the beneficiary, of course, benefits from the trust and things inside of the trust. And there's a quick example that I like to use here. A trust only has control of property that is inside of it. So in my opinion, a trust is kind of like a bucket, all right? A trust is like a bucket. And when you create this trust, you are all 3 of those jobs. And I'm talking about a revocable living trust here. And please ask some estate planning questions in the comments there, and I'm going to get to them in a moment after I explain how a trust is like a bucket. So before this trust exists and before we put anything into this trust, we have to figure out what the rules are, all right? I understand this is probably backwards for you, but this is the rule book. So the rule book says exactly how you want things to go in the trust, and more importantly, how you want things to come out of the trust after you pass away. Where do you want things to go? So hopefully you create this rule book, you and your spouse create this rule book with the help of a qualified estate planning lawyer. So rule book goes into the trust. And a trust doesn't have any power unless there's something in it. So the trust must be funded. We have to fill that bucket, okay? Please ask an estate planning question in the comments. Follow me for more estate planning information. And if you live in California and you don't have any sort of estate plan set up, you can set up a time to meet with me. I do practice all over the state. And we can talk about setting up your estate plan, serious inquiries only. If you want to have a question and answer session, that is what this is for. So we've got to fill the bucket. We've got to put stuff inside of the trust. So for most people in California, if they're homeowners, their most valuable asset is often their home. So we were going to put the home in the bucket, right? So we're going to put the home inside the trust, draft up a new deed, put the home in the trust. We are going to sometimes retitle or title financial accounts in the name of the trust. We are going to make sure that pets are cared for. We can create special pet trusts. I've had people put, well, millions of dollars into caring for their furry little friends, making sure that they are cared for. We can put all of our household goods, electronics, everything up to and including cars into the trust. And then oftentimes what we're going to do is we're going to make the trust itself, and not necessarily an individual, or sometimes an individual first, and then as an alternate beneficiary, the trust can be a beneficiary of a life insurance policy. And yes, I realize this is backwards, but the life insurance policy can go into the trust. So now we have a trust. Now you pass away. You are dead. It's all going to happen for everybody. And the trust is still here though, because we've put things in the trust. And so you've taken a lot of care to craft this trust with that lawyer initially. So when you are gone and you no longer are the trustee, now the trust, the control of the trust passes along to the next trustee, the successor trustee, the person that you have chosen to carry out your wishes as you did when you created that rule book. Okay, so please like this video if you're getting some good information for it. Ask an estate planning question in the comments. I'm going to start going through the comments in a moment here. Follow me for more estate planning information. I've got a bunch of videos that, well, frankly, might answer a lot of your questions. So you're dead. The trust still exists. The new trustee takes over with the trust, but they don't get to do whatever they want with it. They have to follow the terms of the rules as you crafted when you set up the trust. Maybe you want certain things to go to charity. It's up to that trustee to make sure things go to charity. Maybe you want your mother to be able to live in the home that she currently lives in, that's in the trust, until she passes away, and then the proceeds from that home, maybe they go to your kids or your grandkids or a charity or whoever you want. The point is you have control of what happens with this trust. So I'm going to kind of go through some of the questions here, and then in a moment, I'm going to go through the 4 reasons that a trust are better than a will. So I'm going to kind of scroll up here and go through some of the questions. All right. A revocable trust versus an irrevocable trust. A revocable trust you have complete control over while you are alive. An irrevocable trust is essentially unchangeable. So you don't own those things anymore. There are many different types and flavors of irrevocable trusts. Most trusts that I create for my clients that most people need, I'm going to say unless you're in about the top 0.5% or above in net worth, their main estate planning document, we're going to want that to be a revocable living trust. Have I written a book? The answer is no. I put a lot of my knowledge out there on video. I guess there's probably AI could write a book if it read all my videos, if it got the transcripts from all of my videos. So yeah. GM, can a trust own an LLC? That's an excellent question. The answer is yes, a trust can own an LLC. We can assign the ownership, or as we say in business law terms, the membership to a trust. And so the top 4 reasons that a trust is better than a will are cost, control, privacy, and time and hassle. So if you want to know how much it can cost after you pass away in California without a trust, please hit that like button. The cost of probate is expensive. So what is probate, by the way? Probate is the court-supervised, government-controlled, judge-approved asset distribution program. It takes over when you pass away without a trust or without the very specific beneficiaries named on certain accounts. And for most people in California that own homes, guess what? It's not in a trust. It's going to have to go through probate. And the cost of probate is based on the value of what you own. So if you own a $500,000 home in California, it costs $26,000 to get it through probate. By the way, how many $500,000 homes are there in California? The median price in the entire state just hit $900,000, and obviously the median price in some areas, certainly the area where I practice, is well over $1 million. By the way, to get $1 million house through probate, it costs $46,000. $2 million house, $66,000. So we really want to avoid the cost of probate. So what happens is we draw up a deed from the home, for the home. I'm married to Heather. That's, I guess, yeah, that's our wedding picture there. It's a little whited out with the big ring light in my face. So we title the house from me and Heather as individuals to Michael and Heather as trustees of the Michael and Heather Living Trust. That way the home never ever has to go through probate again. Or ever, in fact. That's really the point. So please like this video for more estate planning information. Follow me for a bunch of estate planning information, and share this video. If you know somebody that doesn't have any sort of estate plan set up, whether they're in California or not, share this video with them, because they're going to get turned on, hopefully, to some interesting information, maybe something that might eventually prompt them to take some action to protect the people that they leave behind. Leased cars too. So no, a leased car, no, you cannot put that in a trust because you don't own it. You got to own something. By the way, a home, this is one of the most frequent questions I get. If a home has a mortgage on it, can you put it in a trust? The answer is absolutely yes, a resounding yes. If it is your primary residence, the bank has no power over that home or what happens even to the loan. So I often, between 90 and 95% of the homes that I put into trusts have mortgages on them, oftentimes large mortgages. By the way, remember when I said that the cost of probate is based on the value of what you own, and $1 million house costs $46,000 to get through probate? Guess what happens if there is an $800,000 mortgage against the $1 million house and it still has to go through probate? Does the price go down from $46,000? Nope. It's the value of the home, not the equity in the home. So unfortunately, that loan will either, the home will either have to be sold or someone can assume the mortgage potentially. But yeah, another $46,000 is going to be chopped off of that estate because it was not titled properly in the name of a trust. So please ask an estate planning question in the comments like this video for more, if you like, you're getting information that you haven't heard before or that is interesting to you, and more importantly, follow me for more estate planning information. So let's see here. I'm going to go through some other questions. How do you do estate planning? Well, you write documents. You have a conversation with people. In a very simple term, way of saying things, I talk to people, I figure out what it is that they want to do with their body and their stuff, both while they're alive and when they pass away, and then I come up with a set of documents that hopefully somewhere between 50 and 150 pages that lays that all out in very specific legal terminology. So that's what you get when you buy an estate plan, when you hire a lawyer to create an estate plan. But you're not just getting that, right? You are getting advice from a lawyer that hopefully knows what they're talking about. And hopefully you are getting peace of mind that whoever comes next, whoever follows you, whoever comes after you, follows in your footsteps, is not going to have to go through a lot of hassle. So the top four reasons that a trust are better than a will: cost, control, privacy, time, and hassle. We talked about the cost of probate, now control. Now I've got a question for everybody in this audience. If you think you would have not made good decisions with $1 million, if you think you would have not made good decisions with $1 million the day, if you got $1 million the day you turned 18, like this video. Because if you pass away and you are the beneficiary, let's say of an insurance policy, or there's $1 million home that's going to you and there is no trust set up, you get all of it. And that can unfortunately lead to bad decisions. What age is it? In the comments, what age is it that people's brains fully develop, their frontal lobes? 23, 24, 25, 26, maybe a few years later for boys, that sort of thing. So what a trust does is it gives us control. And it's more than just, even if we want to leave things to our kids, first we can put, let's call them guardrails around how things are inherited. Maybe we want them to attain a certain level of education before they start inheriting things. Maybe we want them to get a professional certification or a bachelor's degree, or start a business, or be doing something productive with their lives. Maybe we want them to reach a certain age before they start inheriting money. Maybe we want them to be 21 or 25 or 30 or 35 or 40 before they start inheriting huge chunks of money. Or maybe we want them to take a personal finance course, and a trust allows us to do that. It allows us to put provisions on how people can inherit things in a way that a will cannot. So control is really essential here. And obviously, if you want to leave more to one child than another child, you want to cut a child out, you don't have children, and obviously you want to give things to nieces or nephews, siblings, parents, friends that are never going to get anything if you don't have any sort of estate plan set up, and of course charities, then we want to make sure that we have control over that. So please ask some questions in the comments here, and I'm going to, Japer 6886, why the difference in price if it's a process thing in probate? I don't have a good answer to that question. The probate system is very old, it's very old-fashioned, it's very archaic, it's a mess, and it is actually based on a percentage of value of the estate. And in California, because you have high home values, as the value of what you own goes up, the cost of probate also goes up. Where does that money go, by the way? Lawyers. Lawyers take cases through probate, and we have to put ads out in the paper and contact all potential beneficiaries, and even to get an initial court date, it takes several months, and you have to wait more months to do this and more months to do this. It takes a long time. Well over a year. I have heard of people that have had estates in probate for 6, 7, 8 years, having to locate third cousins in Japan, and it's a total mess. We really want to avoid that. Ava says, thank you, I need an estate plan. Everybody needs an estate plan if you're an adult. Remember those key 3 documents that I haven't really spoken about yet. I've really just been speaking about trusts, but an estate plan is more than just a trust. How to put a home in a trust. So to put a home in a trust, what you do is you write a deed. You draw up a deed or have someone do it for you, deeding the home from your name as an individual to you or whoever the trustee is going to be while you're alive of the trust that you have created. Now, in order to do that, and then you file it at whatever county records office there is. In California, there are 58 counties. I've put houses in trusts in about, I don't know, I'm going to say 14 of those counties, all of the largest counties. There's a lot of small counties in California. There's some that have like 10,000 people in them. So there's a lot of counties. So please like this video if you're getting some decent information from it. Follow my page for more estate planning information and ask a question in the comments there. By the way, I'm not doing this for my health. I run a business. I'm a lawyer. I have clients that pay me to set up their estate plans. So if you happen to live in California and you don't have any sort of estate plan set up, or you did a long time ago and there has been a very big change in life circumstances like a marriage or a divorce, or kids have grown up, or you want to change things around and you want to set up a time to talk to me about your estate plan, you can do that. You just go to my profile page, you click the link in there, go straight to my website. You can set up a time to meet with me for free. I call it a strategy session. We have serious talks about your estate plan. If you want to ask questions, have those questions answered, this is the place and the time for doing that. And by the way, what's my background? Okay, well, I'll introduce myself again. My name is Michael Pevney. I am an estate planning lawyer in California. I practice in all of California. My office is located in, and I live in Orange County. But I have a bit of a social media presence. I have about well over 100,000 followers across all of these social media platforms. Most of them are on TikTok. And the comments that I get from people when I ask them to leave me a review, or they say you explain things really well. And that has caused me to have a little bit of a reach geographically. Now, I only practice in California. I don't practice in any other states, although some of this information might be useful to you if you are in another state. But I do practice all over California. So I have had many clients in the sort of Silicon Valley, Santa Clara area, San Jose, all over Alameda, Contra Costa, Solano, all of those areas. Plenty of clients that have found me on TikTok. We're able to do things remotely, and eventually when it's time to sign documents, I am on a call just like this. Either this is my home office, but I have a similar background at my office. So, and I am there guiding you through the estate plan document signing process after I've sent a notary to your home to do that. And so I've been practicing law for a total of 17 years. I only practice in the area of estate planning. That's the only thing I do. I set up estate plans for people. And if you just, if you just Google my website or my last name, or my first and last name, Michael Pevney, you're going to come to my Google profile. I've got well over 100 5-star reviews. So if considering setting up an estate plan is something that you would like to do, and it's time to do that, or you need to do it, you can go to my website and set up a time to talk with me. But if you just have questions, those aren't question and answer sessions. I consider my time valuable, including this time where I like to give people information. By the way, I'm not your lawyer yet, unless you've already hired me. All right, so I'm going to try to answer some questions here. If you have a tax lien on a property, can you put it in a trust? You cannot put it, what you cannot do is put it in a trust to try to avoid that, because a mortgage is a lien on a property. And if you put a home with a mortgage on it into a trust and it's your primary residence, you're absolutely able to do that. So please like this video if you're getting some good information from it. Follow me for more estate planning information, and yeah, just like this video. So I'm going to keep answering some questions here. Can you have a homestead on your home if it's in a California trust? The answer is yes. The homestead laws in California protect, depending on the county you live in, up to about $600,000 of equity in your home. if there were to be a lien or a judgment or a bankruptcy or something like that. So, and if you put that home into a living trust, into a revocable living trust, that those homestead protections do remain on there. Let's see. Passing without a trust or a will and leaving a property. Kids wanting to keep property in California. Yeah, it's going to be a mess. It's going to have to go through probate. Maybe if it's going to more than one person, there might be squabbling. By the way, here's a super common scenario. And like this video, if this is something you have ever heard of, somebody passes away. They've lived in the home, they're older, they've lived in the home for 20, 30, 40 years. It's worth a lot more than they paid for it. And they have 2 or more children, 2 or 3 kids. And maybe one of the kids happens to be living at the home at the time. Maybe one of the kids lives a little bit further away. And maybe one of the kids is more successful than the other 2 kids. Guess what? According to the probate laws, everything's going to those 3 kids. It's all going into their name. And I think there's going to be a disagreement on what to do with it. Maybe one kid wants to stay living in that home. Maybe one kid wants to sell the home, split up the profits. Maybe one kid wants to rent out the home and use it as an investment property. And how's that going to be figured out? What's great about a trust and properly setting up an estate plan is you get to say what happens. Either you can say, sell the house and split it up, or I give this child the right to live in the home for 5 years and then they have to leave. And by the way, where are the mortgage payments coming from? Where are the property taxes coming from? Where's the maintenance and the insurance coming from? We spell that all out in a trust. All right, revocable living trust is enough to avoid probate. Nerd Million, you're absolutely correct. Let's see. What are some of the basics someone needs to avoid probate? So a great way to avoid, there are several ways to avoid probate. First of all, it depends on the kind of asset you're talking about. Any sort of account that you own, this is getting a little more financial, anything from a bank account, checking, savings, CD, non-retirement investment account, 401k, IRA, 457, 401, 403b, life insurance. If you can name a beneficiary, name a beneficiary, because it will not have to go through probate. Essentially, that beneficiary shows up, they present your death certificate, and the fact that on their records you're going to be listed as the beneficiary, so that's a way to avoid probate. Joint ownership of property is also a way to avoid probate. However, I always caution people, please do not put your kids on the deed to your home. It's a recipe for disaster. Yes, it avoids probate, but when it comes time for that home to be sold, the kids are most likely going to get crushed when it comes to capital gains taxes. We have capital gains tax bills in California of well over 6 figures. The tax bill, well over 6 figures, just because somebody wanted to do a sort of end around getting a trust, properly putting something into a trust and getting around probate, but then they don't get around capital gains because the tax basis has not adjusted. And so a home that was bought for $50,000 is now worth $1 million. Now there's $950,000 in capital gains, and now whatever 20% of $950,000 is well over $100,000. So don't do that, please. So please like this video if you're getting some good information from it. Follow me for more estate planning information and ask a question in the comments. All right, can a house owned by 2 people be put in a trust? Do we need the signatures of both owners? If you want to get really, really technical about it, maybe one person can put their half into their own trust. But typically if we're dealing with a married couple, it's going to be the married couple that set up that trust on their own, and we're going to need both signatures. I have done situations like that where you can put one person's half into a trust without the other person knowing. We need to be very careful about that. Make sure what the law says. Make sure that the specific part of the law is referred to, so it can be a little bit tricky. Best way to protect a structure, an irrevocable trust, who is trustee, beneficiary, etc. Yeah, irrevocable trusts are a little bit tricky. I'm sorry, I got my my brain development questions here. Yeah, 25, 26, all of that, most definitely. Okay. Tax makes sense. Clever name. There is a pour-over will. Yes, there is. So I've really just been mostly talking about trusts here. And An estate plan is more than just a trust, a complete estate plan. We have other documents, some of which act as, call it a safety net, okay? So we have the trust is oftentimes the sort of central estate planning document, but we're always still going to have a will. It is a very basic, very simple will that we call a pour-over will. The will leaves everything to the trust. So it's a very brief will, and it says essentially that things that don't make it into the trust, that don't make it into the bucket, either while you're alive as a title change or as a beneficiary of a financial account that you might own, is left to the trust. The trust is actually the beneficiary of the will. So yes, a pour-over will is also an important part of an estate plan. Now, we have other documents. We always want a financial power of attorney who is able to care for your finances if you are not. So please like this video if you're getting some good information from it. Share this with somebody that doesn't have an estate plan, no matter what state they live in, especially California. If you own a home and you've never talked about that home being in a trust, it's probably not in a trust. I have access to all that, like I can just type in my street name and I can see whose home's in a trust and who's not. And it's about 20% of them are in trusts, and the amount of money that's going to be wasted in probate is just, I don't want to say criminal because yeah, it's legal, but it's, you know, legal theft, right? It's a mess. So please share this video and share my account with them. My parents, myself, and husband are on the deed and the mortgage. Can I do a trust for my parents? Yes, you and your husband would have to sign, you know, no longer be owners of the home. But if you wanted to avoid that mess of capital gains, putting it in a home in their control with you as the beneficiaries is often going to be a good way to do that. Having a bunch of people on the deed, yes, can avoid probate. What that means is the last person living has complete control and ownership of the home. With a trust, we want a little bit more control over what happens, and we definitely want to avoid any messy capital gains problems happening in the future. Am I part of the ARAG legal insurance program? The answer is no. You pay for my services. I am not part of any insurance networks. Is it possible to sell your home after it has been placed into an irrevocable trust? Maybe. Depends on the terms of the trust, depends on who the trustee is, depends on who the beneficiary is. There's so many types of irrevocable trusts. They can be used for certain reasons, oftentimes Medicaid reimbursement avoidance. Thankfully, in California, that is no longer an issue as long as it is in a living trust or any kind of trust, really. If it does not have to go through probate and you're on Medicaid, they can't come after your house if it is not going to be going through probate. Okay, can you explain capital gains more? All right. There's something called basis, all right? So let's say somebody bought a home for $100,000 and it's now worth $1 million, and they sell that home. So it has gained $900,000. That's $900,000 in capital gains. That is a type of income, although it is taxed a little bit differently. There's like a 15% tax rate and a 20% tax rate. I'm not an accountant, but I do have to know a little bit about this. So what happens is, to avoid kids ever having to pay that $900,000, that taxes on the $900,000 in capital gains, what happens is there is what's called an adjustment of basis, or a step up in basis. So if the home is in a trust, or if it passes by way of a will from parents to children, and the home is worth $1 million when the parents die, but they bought it for $100,000, it is as if the kids inherit it, it is as if the kids bought it for $1 million, for what it is worth on the day that the parents passed away. So if the home is sold shortly thereafter, there will essentially be no capital gains taxes owed. So capital gains can be a little bit of a sticky situation. There is that step-up basis when somebody passes away. That also does include things like stock that is not kept in retirement accounts, and that does include things like real estate. There is a step up in basis, which is why we want to retain that by putting it oftentimes into a trust. So please like this video if you're getting any information from it. Share it with somebody that doesn't have any sort of estate plan set up, and follow me for more estate planning information. I'll introduce myself one more time. My name is Michael Pevney. I am an estate planning lawyer. I'm located in Orange County, California, although I do practice all over the state. And so if you do not have an estate plan set up, you can set up a time to meet with me like this over Zoom for free if you're serious about setting up an estate plan. If you want to ask me a bunch of questions, ask them here. I have over 700 videos on TikTok. I've almost undoubtedly answered your question in one of those videos. So let's see. Harneet, estate planning attorney here in California. Thank you very much for the kind words. I really appreciate that. It's an interesting world out there. I like being an estate planning attorney. I did do criminal law litigation for a long time. I find estate planning to be a lot more collaborative. Estate planning lawyers are really helpful to one another in terms of asking questions or getting help or finding somebody local if that's something that's important to somebody. So I really appreciate that. That's very kind to you. That's very kind to me. Okay. So yeah, please ask those estate planning questions in the comments. I skipped over a bunch of them. Let's see here. Trust was funded with real estate only, not cash, retirement, etc. Will that create an issue? No. If a trust can be funded only with real estate, that's totally fine. So whatever's in the bucket, right? Whatever is inside of that living trust means that the trust is funded. Now, what it does mean, though, is that anything that isn't in the trust may have to go through probate if there are no beneficiaries named on that. So that can be a mess. All right, where do I start to put a trust on my home? A realtor or a bank? I would start with a lawyer, with an estate planning lawyer. If you have a realtor that you trust, most decent realtors, by the way, if you are buying a house, they should ask you how you want to title the house and do you have a trust? Do you have a living trust and have you thought about doing that? Savvy realtors that, in my opinion, have a lot of care for the well-being and ultimately what happens to their clients will often broach that subject on how title is taken and, well, do you have a trust? Have you ever considered that? Do you know what the benefits are? You know why? Because a lot of realtors have had to sell a home that's going through the probate process. And every time I talk to a realtor that's hired me, I'll say, how long is the longest amount of time that you've had to wait for a home to go through probate, or has a home been in probate? And the longest I've heard is like 8 or 9 years. So it's a total mess. All right, Gwenny, maybe a dumb question. Can my husband and I have one trust, or do we each need our own? That's not a dumb question at all. Typically, we are going to create one trust for both spouses. So one document that both spouses are going to sign, unless you have some sort of a prenup or a postnup in place. At least where I practice in California, this is a community property state. So from the moment that you get married, any earnings from either spouse, doesn't matter how one-sided it is, any earnings from either spouse after the date of marriage becomes community property. And so creating a trust for one spouse only is very difficult, is a web of a mess of gifting problems, separate and community property problems, and all that sort of thing. So yeah, if it's a married couple, you pretty much got to set it up separately. If it's a married couple, you pretty much have to set up a joint trust together, unless you have a prenuptial agreement or a postnuptial agreement in place. By the way, what's the difference between a prenup and a postnup? This isn't a joke. A prenup is done before you get married, and a postnup is after the marriage actually happens. It's just a property agreement laying out what belongs to who, what is community property, what is separate property, that sort of thing. So please like this video if you're getting some good information from it. Ask an estate planning question in the comments, and follow me for more estate planning videos, because there's a lot of them out there. All right, let's see. Do I create a trust or an LLC first? Well, it depends what your goals are. So an LLC stands for Limited Liability Company. LLCs are for businesses. So for example, you can't really put your primary residence inside of an LLC because its primary purpose is not a business. So if you have a rental home, however, now that can be put in an LLC, and then the LLC can be put in the trust. So I do have some clients that have rental properties. Sometimes they're in an LLC, maybe an individual one, maybe one LLC covering more than one property. And then we actually don't have to file a new deed with the county. We just transfer the membership of that LLC into the trust. So you can have a home inside the protection of an LLC that's going to protect your personal assets from liability, and then all of that can be inside of the trust, protecting the LLC and the house inside of it from ever having to go through the probate system, which is a good thing to do sometimes. D.Y. Excellent question. Will my property taxes go up once I change my title to the living trust? In California and most states that I'm aware of, no. The answer is no. Property taxes are such a huge deal in California. It's so crazy. If you have somebody that bought their home for $100,000 40 years ago, and next to it is the same model house that's worth $1 million, there is such a difference in the amount that they're paying in property taxes because it's all based on the purchase price of the home. So the person that's bought the house for $100,000, they might be paying like, it goes up a teeny bit every year, but it might only be $1,500 to $2,000 a year. The people in the $1 million house that just bought it for $1 million are paying $10,000 a year. So that is a huge issue, and the state is trying to remove as many exemptions from property tax reassessment as possible. But yes, thankfully, putting a home into a living trust will not affect your property taxes in California. There's pretty crystal clear law that placing your home into a living trust for your own benefit is an exemption from a reassessment in property taxes. I personally put somewhere between 2 and 5 houses every week inside of a trust. File a new deed with whatever county that house is in. I'm talking California here, and never had a reassessment issue ever. Every once in a while there is a question here or there was an issue about an add-on that I didn't hear about, and the people at the county are surprisingly easy to talk to. You just kind of call them and they'll pick up. So yeah. So please like this video if you're getting some good information from it. Share this with somebody that doesn't have any estate plan set up, and follow me for more estate planning information. This is my job. This is what I do. All right, so we have another corporation question here. One vending machine. Do I need an LLC? You probably need insurance. An LLC has a cost to set up. It has a cost to maintain. It has its own tax ID number, both state and federal, and it has to file its own taxes, which means you probably need an accountant to do that. So that's just a little bit of a cost-benefit analysis. If it's a business, you need, maybe some sort of insurance. We've all heard stories about people getting killed by vending machines, right? Falling on them, trying to just keep shaking that thing, right? All right, so long as the LLC isn't an S Corp or you lose step up in basis when you die. Yeah, you should not have, there should not be an issue if there's a step with the step up in basis it depends on who the owners are. Okay, so it depends on who the owners of and how the business documents and the articles of incorporation are worded. Now, hopefully they should be worded in such a way to where, well, if you are in control of everything now, and then when you pass away, it goes to somebody else, yes, that step up in basis should be maintained. My boyfriend and I have 2 houses. Should we wait until we get married to create a trust? Well, Crystal, that's kind of up to you. You can certainly create separate trusts if you want. Waiting until you get married is going to certainly, you're going to want to create it together. Now, this is the very unromantic thing to say, but you already own you have significant assets before you get married, and that's when it's time to start thinking about a prenuptial agreement. Most people don't have them. I don't have one. My wife and I were in a bunch of school debt when we got married, and so we didn't see any need to, and things are looking good so far. But that's something that, as a lawyer, that's always a conversation to have. Yeah, I might consider waiting, because things can become very messy if you set up two separate trusts before you get married, but then after you get married, everything becomes community property, or parts of things become community property. And that's where things can become a legal little bit of a mess. So yeah. Do I work with slats, Q-tips, etc., and more complex estate planning? Depends. Q-tips, yes. Slats, yes. Eyelets, yes. Some of it depends on your net worth and what your goals really are. I am the only attorney in my firm. I am a sole practitioner, although I do have some staff. But when people get up to, I'm going to say, in the range of about $25 million in net worth, $25 to $50 million, I'm likely going to start maybe bringing a different estate planning firm into the conversation, a firm that has accountants, a firm that has lawyers that specialize in creating business entities and that sort of thing. Which I think maybe about, in my opinion, about how I'm trying to figure out. So you have high net worth, super high net worth. I mean, we're talking about the top, somewhere between 0.3 to 1/2% of net worth. Am I seeing any more irrevocable plans due to the change in the estate planning, or rather in the estate tax exemption? Yeah, there's some concern about that, but the exemption limits is still going to be probably around $13 million for a married couple. And I don't like to predict what the law is going to be in the future, but I do have a little bit of a feeling, actually, no matter what happens in the election, that that's going to get extended. Oftentimes, tax breaks and tax exemptions and tax rates are not clawed back and go up, oftentimes. All right, I'm in my principal home, but I also co-sign for my sister's home. Do I need to add her in my trust? It depends on who is on the deed to the home. Doesn't matter who's on the loan, it matters who's on the deed to the home. The person on the deed to the home owns the home. The person on the deed to the home decides whether or not the home can be sold. The person on the loan to the home is responsible for paying it. If the person doesn't pay that loan, the loan can be foreclosed on and the home can be eventually seized. So it's not a question of who's on the loan so much as who's on the title to the home. So again, my name is Michael Pevney. I am an estate planning lawyer. I practice all over the state of California. I've got, on TikTok, I think I've got about 65,000 followers or so. People from TikTok all over the state have hired me, people just like you. And feel free to ask an estate planning question in the comments. Follow me for more estate planning information. And okay, you're on the deed, then it's your house, unless it's both of your names. In which case you kind of need to figure that out and see if you can get maybe your name off that deed, and sister probably needs a trust of her own. Life insurance and investments in the stock market. Do I need a trust for this? Need? No. But depending on where you want things to go when you pass away, you might want to consider that. So if let's just say you have 7 figures, or you have $1 million life insurance policy, and you have 2 kids, and those kids are, let's say they're young adults, and you passed away tomorrow, do you want all of that money going to them with no strings attached, or might you want to attach some sort of guardrails around that? Maybe you want to wait until they're 25 to start inheriting things. Maybe you want somebody to be able to watch over how that money is spent until they're a certain age, or they've reached a certain level of education, or we want to make sure they're making good decisions. Or maybe we want that money protected for a certain amount of time from something like a potential legal judgment, or a bankruptcy, or a potential divorce. And if there's a legal judgment against somebody and they inherit $1 million, guess what? That $1 million is out the door if the judgment's for more than $1 million. With a trust, if somebody inherits things by way of being a beneficiary of the trust is actually not allowed to comply with legal judgments in that case, if that's allowed. And this is typically when we're talking about parents passing things along to kids, or when somebody passes away and a revocable trust comes along and becomes an irrevocable trust after it passes away. So do I have to refinance a house I inherited with a mortgage? Typically, no. They will often ask you to assume the mortgage under the current terms. In my experience, banks are just, as long as you're paying the mortgage, nobody's gonna care all that much. And yes, I understand we're in a different interest rate situation. And yes, there might be a 2.5% rate on the mortgage. And now if you were to refi, it would be 7%. But as long as that mortgage keeps being paid by the person that it inherits, especially if it's a child or a grandchild, it's usually not going to be a very big deal to the banks, although they might want you to become financially responsible, but not necessarily make you qualify. So it's a little bit of a trickier question. My uncle has 2 homes and 2 daughters. He feels the older is more responsible and wants to put both what on the deed? If you put both on the deed, that means that the more responsible one gets them and gets to do whatever they want with it. If we want both children to benefit from the homes equally, then we put the homes in a trust, make the kids beneficiaries, and the terms by which they inherit things, maybe they're the same or maybe they're different. And when I say terms, I don't mean amounts or percentages. I mean half and half, but I mean maybe with the less responsible child, we want somebody watching over their share of their inheritance. Maybe it can only be used for certain things like health, education, maintenance, and support. Maybe if there happens to be a history of making bad decisions or even substance abuse, we put terms along there to make sure that if they are making bad decisions for themselves or this money is ultimately going to harm them, that the trust prevents them from doing that. So again, please ask your estate planning question in the comments. What time is it here, you guys? I mean, I got little kids to put away. Let's see. All right, someone is asking to join live as a guest. I've actually never done this before, so let's see what happens and if I kick you off or not, or how to do that. Okay. What taxes are paid on LLC property sold from shareholder capital gains or income tax? If it is from earnings, because an LLC is a pass-through entity, so if it is earnings, then it should be income tax. But if it is, if we can assign a value to the membership of the goodwill or whatever it is of the business, then it should be capital gains. I'm not a CPA, I'm not an accountant, I'm not your lawyer. Ask them about that because I'm not doing that sort of things. Okay, let's see. What type of estate tax buffers are there? So there are a few things that we can do. Something called a charitable remainder trust, making sure that, yes, if you and your spouse have a net worth of over $28 million and we don't want every dollar above those $28 million to be taxed at a very high rate, we can put in gifting strategies, charitable giving strategies. Some of those strategies involve life insurance. Let's see. Santana, message me if I can hire you. If you're in California, you might be able to hire me. You can follow me for more estate planning information. And if you live in California, what you can do, if you are interested in actually setting up an estate plan for yourself and you know it's something that you need to do, especially if you own real estate, you can go to my profile here and connect directly to my website. And there, you just click on the button to set an appointment, a strategy session we call it, and you set up a time that works for both of our schedules. And we meet over Zoom and we talk about your estate plan. All right. All right. Do I work closely with any CPAs for 706s? Yes, I do work with a couple of CPAs. Can you put a business in a trust? The answer to that question is yes. Yeah, we put businesses in trusts all the time. LLCs, S Corps, depends on the ownership structure of an S Corp. Certainly if it's owned by one person or two spouses, we can always usually assign those shares to the trust. Not a difficult thing to do. So I'm going to head out now. And I really appreciate everybody that's been here watching me for a little bit. If you just got here and you thought this was interesting, just follow my page. That's the easiest thing to do, is just follow me up my page for more estate planning information. There is very likely a good chance that, I think that's redundant. There's a very good chance that whatever question that you have, I have already answered it in a video. And so once again, my name is Michael Pevney. I'm an estate planning lawyer. Like this video if you've gotten some good information from it. Follow me for more estate planning information. And if you live in California and you don't have that estate plan set up and you know that it's time to get it done, people have been talking about it, somebody's been nagging you about it, or maybe there's been a life event, somebody's passed away, or there's been a major life event like a birth or a marriage or a divorce. You can set up a time to talk to me about your plan. You go to my TikTok profile, you go to my website, you click on schedule a strategy session, and we pick out a time that works for our calendars, and we figure that out. All right, take care.